We're not convicted yet, but a convicted prisoner will get treated better than we will, and we haven't been convicted yet.
Remanded now until the 28th. Have you been in this prison before?
No, sir.
Now step behind the screen, take all your clothes off, pass them to the prisoner there.
White cotton on the band, sir.
The remand centre, Risley, Lancashire. Last year, 38,000 people found themselves held prisoner in places like this. These people have not been tried. No court has yet judged their guilt or innocence. Probably they asked for bail, the right to remain at liberty until tried. They did not get it.
Well, apart from being in here, like, I could be working and giving my wife money to help us, whereas I can't do nothing while I'm in here.
I have a wife and a daughter, and I was arrested, and I've not seen them since, and I feel completely cut off. I sent my lawyer a telegram, and he sent a conversation back by the telephone to the court, as it was such short notice, as he couldn't make it. He was otherwise engaged. So on my appearance, I just had no solicitor at all.
Is any message for him when I go?
Because Risley takes prisoners from all over the northwest, families can travel up to 200 miles to speak through a wire grill for a visit limited to 20 minutes. This remand system treats every untried man like a maximum security risk. If he refuses to do manual work for 7p a day, he will find himself locked up in his cell for 23 hours out of every 24. Deputy Governor Jackson Burford.
The person who has no knowledge of prison life may well be surprised that the untried man does not get the same sort of facilities as the convicted man. But to the person who is working in a prison, the untried man is an unknown quantity, and therefore the security conditions have to be greater than those required for people that you know better.
The present remand system is harsh on the innocent man and the petty offender. It in fact works as guilty till proven innocent. Theory and practice are back to front. In the last 3 years, 113,000 people spent time in prison awaiting trial. Almost half of those found guilty were not sent back to prison. And 6,000 of those who were remanded in custody were later judged innocent. Tonight there are 2,000 people in prison awaiting trial. A half of them, when they're tried, will be freed.
Well, I knew in my own mind I was innocent, but, you know, you try to convince people when you're inside the prison, you can't convince anybody that you're innocent until you actually go into court and be found innocent.
Michael Underwood was arrested after a club brawl last February.
I was always understand the law was innocent till proven guilty, but when you're behind walls, it's very different.
At the time of the brawl, he was on crutches. He claims he could scarcely keep himself upright, let alone attack anyone. All the charges against him were dismissed.
After the fight started, they stood up to see what was going on. A person came over and took one of my crutches, started swinging it about in the club. So I thought, well, you know, what's going to happen to me? And
Gordon Bostock was also in the Brighton club with Underwood. He too faced charges arising from the fight. He was found guilty on one minor count. Police opposed bail for these two men on more than 20 occasions, and each spent 3.5 months in prison. After the trial, they were freed immediately. Neither has received any compensation.
We were sort of committed in custody to appear before the Lewis Assizes, where we was then remanded back to Lewis Prison again to come to Lewis Assizes, you know, sort of on the following, I think it was a fortnight, something like that. Lewis Assizes didn't think that the charge was serious enough to sort of be held there, so they sent us back to the Quarter Sessions. And the Quarter Sessions said that they still thought the charge was serious enough, so they sent us back to Lewis Assizes. And then Lewis Assizes decided that it definitely wasn't serious enough, so they then sent us back to Brighton Quarter Sessions again. But, you know, sort of by this time, I think some sort of 2 months had gone by before we got we knew when we was going to get a final date to appear, you know, at the quarter, so at the Quarter Sessions. And then we appeared, I think it was another 6 weeks, something like that. Yeah, the first time they objected to bail, the man in the case was seriously injured and was in hospital, sort of dangerously ill. Well, he was supposed to have had a cracked skull. Anyway, he had a black eye. It was sort of found that he came out of hospital because, you know, the man was a steeplejack and he was sort of climbing steeples the next day, you know.
In my case, I suffered, and a lot of other people can suffer through the same way. I mean, it was a silly case of, I think, police being more or less pig-headed about this, you know, remanding us all on certain charges and against witnesses being interfered with. There was no case to answer. I mean, it showed it at the end of the trial, actually, when I got found not guilty. I mean, I pleaded not guilty all the way through. I mean, they were saying you did this, you did that. But, I mean, regarding bail, I had no special reason, no, I mean, they trumped up a lot of things which to hold us on, you know, remand. And I felt very bitter. I still do now.
So then they objected to bail on the grounds of a witness that had been intimidated and the seriousness of the charges, and that there would be further charges sort of to add to. At that time he was only charged with an affray and sort of fighting in the club and malicious damage.
For 3.5 months it was very hard to explain to young children where Daddy is, and to a little girl who absolutely dotes on her father, just can't understand why Daddy's not here.
David Napley is a leading London solicitor and the chairman of the Law Society's Criminal Law Committee.
The purpose of bail, right down from Magna Carta and the Bill of Rights, has been that a person should not be incarcerated until he's been proved guilty, unless there are very strong reasons for doing so, that bail should be granted. Within that general broad principle, certain other considerations have arisen, namely whether the man is likely to attend his trial, which is the primary consideration, and secondly, whether there's any likelihood that he'll commit further offences. Thirdly, what is his general character, what is the nature of the offence. Those sort of factors are operating on the mind of the justices, and they know that those are the factors they should take into account.
In theory, bail laws protect the individual. In practice, a bewildering variety of seemingly inconsistent decisions are made. Some people spend weeks in jail before eventually getting bail. First applications are often refused. Sometimes bail is eventually granted by the very court which originally turned a man down. This man actually got bail, but spent 6 weeks in prison because nobody told him. This man also spent 4 weeks inside. The police refused to believe his family had moved house. This man spent 5 weeks inside. He was offered bail but couldn't find a householder to stand guarantee. John O'Connor could only have bail if he found 2 sureties of £250, guaranteeing he would turn up for his trial. These guarantors also had to be householders. O'Connor himself earned £12 a week and lived in a bed-sitter. He was later acquitted of a charge of attempting to steal a carpet during a Vietnam demonstration in London, but not before he'd spent 5 weeks in Brixton trying to find friends outside who owned a house.
The police only have one set of forms of application for sureties, and this means that somebody held on remand who's been allowed bail can only apply to one surety at a time. 3 sureties refused. It would take the whole of the month for him to go through this procedure and perhaps apply to a 4th. Although my brother-in-law is a qualified doctor and my sister had a regular job as well, they were refused sureties because they lived in a furnished flat. Any surety, anybody who I thought that might stand bail for me, the people, my friends, automatically, most of them live in flats, and were automatically excluded by the police from standing surety for me.
This lady was celebrating her 83rd birthday when we called. She has a chronic heart condition and is normally bedridden, but that didn't stop her being charged with unlawfully and maliciously wounding a 22-year-old man who lodged with her family. She got bail, but her son-in-law did not. Sam Smalling, his wife, and his 83-year-old mother-in-law were all charged with assaulting their lodger. In fact, the lodger's wound was self-inflicted, and the Smallings were eventually acquitted. But Sam Smalling was held 4 weeks in jail before a solicitor intervened. The police had their facts wrong when objecting to bail. They said Smalling was still living in the same house as the lodger, when in fact his family had already moved. There were therefore no valid grounds for denying Sam Smalling bail.
It was my first time in jail, and when I got there, everything was strange to me. The first night when I when I went there in the prison, I was hungry, and so I asked them if they could give me anything to eat, because I just leave work and go home to get dinner, and they just take me away to the jail. And they say nothing at all I could get. And in the morning I get 2 sandwich, egg sandwich.
According to how it was going and the sayings and the worries, I believe, I wasn't looking for him to come back, because it looked so difficult, and just like the world was against us.
I know that innocent people go to prison the same way. It's all depends. Plenty of people go to prison innocent.
A man who has been acquitted of a criminal offence should at least be entitled to obtain some compensation for what he's gone through, upon the basis that the system has broken down somewhere and the individual ought not to bear the expense of it. In a legal system, as with ordinary human beings, moderation is the order of the day, and you've got to look at this thing sensibly and objectively. And so far as I could see, the answer is that the court should have a greater regard to the fact that a man should be presumed innocent until proved guilty. I think the pendulum has swung a little away from this in regard to applications for bail. I think it needs to be readjusted and brought back.
The Criminal Justice Act of 1967 should have helped. Yet today there is an even higher proportion of untried prisoners in British jails, although all magistrates are under firm instructions to be more liberal with bail.
One would have expected, if the Criminal Justice Act provisions had worked, that situation would have altered. The fact that the figures have remained fairly constant, if not increased, seems to indicate that the desire of Parliament that bail should be more freely granted is not being carried into effect.
Previously, there has been very little accurate information on bail. To cut through the speculation, World in Action sent a team to cover 16 courts in the London area. Our team stayed for a week and listened to hundreds of cases. We wanted to know how often bail was refused, what the relation was between police objection and refusal of bail, and how many bail applicants had legal representation. Our researchers attended over 500 bail hearings. 306 of the accused were lucky. They got bail. The others, 2 in every 5, were kept in custody. The magistrate apparently felt no strong impulse to grant bail and keep the untried out of jail, or challenge the police. When police opposed bail, the magistrate agreed with them 4 times out of 5. The number given bail against police objection was only 1 in 8. Lawyers helped only 1 accused in 5, and to appeal costs money. Legal aid won't pay for an appeal. One disturbing factor: in court the magistrates failed to inform almost half those refused bail of their right to appeal. Magistrates seemed to show more interest in what the police said when objecting to bail than what the accused might say about his job or family. Yet these home ties are what bind a man to reappear in court for trial. Even when giving bail, in 2/3 of the cases the magistrate had no domestic details on the man freed, and most of what information was given came from the police. Yet the magistrates appear to have sent 2 in every 3 accused to jail to await trial without knowing the vital details of the accused man's job and family ties. When refusing bail, the magistrates seemed strongly influenced by fears that the accused might have a previous record. Now the accused may spend 23 hours of every day locked in a cell. The normal wait before trial is at least 4.5 weeks. The average hearing in our survey took less than 5 minutes.
Well, the quality of evidence is of necessity only a reflection of the depth of the inquiries which have preceded it. And the depth of the inquiries which precede applications for bail at the moment are shallow in the extreme. They're most inadequate. And the truth of the matter is that the system is wrong. I don't think one can put the blame here on the police or on the magistrates. I think the system doesn't enable adequate inquiries to be made or sufficient information to be made available to the court to enable it to make a reasonable value judgment.
Justice Kelly? Yes. My name is Mrs. DeVos, and I'm with the Office of Probation. I'd like to ask you some questions to determine whether you might be released in your own custody and to assign you an attorney if you don't...
In New York, they do things differently. This probation worker is collecting details for a judge to make a decision on bail. She's not concerned with the man's alleged crime or any police objections. These are matters for the judge. The probation worker is preparing a recommendation based on a point system which will tell the judge if the man's home circumstances are stable.
Brooklyn.
Where do you work, sir?
Acme Fire Insurance Company.
Where is this located?
515 76th Avenue.
Probation Service Chief Jack Highsmith.
We deal in Manhattan anywhere from 500 to 575 cases per day. We work 24 hours a day. We work every day, 7 days a week, holidays included, Saturday, Sunday, Christmas, and all the other days. After we make a recommendation to the judge to have the person ROR, to release in his own recognizance, we have another worker who in turn will send out what we call a letter to the defendant to remind John Doe to come back to court on September the 18th. We also send a letter to the person that we verified this case from, either his mother, father, sweetheart, or employer.
Concerning your father, Mr. Joseph Kelly. Yes, Mr. Kelly has been arrested. No, I'm not authorized to give the charges, but we would like to ask you some questions to verify the information that Mr. Kelly has given us.
Of the, let's say, 100 cases we handle, we would say 85% of those we would submit with a recommendation. Maybe the other 15% we would submit without a recommendation. Some days more, some days less. If the judge were to let out that 85% on a recidivist basis, we have a small percentage, something 2%, as opposed to the bail people who do not come back.
This scheme saves New York £1.5 million a year. American experience proves that 4 times as many people can be released on bail, and the number of defaulters can be halved. The New York scheme was prompted by the dangers of an inefficient bail system. Its initiator was Herbert Sturtz of the Vera Institute.
We also found that there was not only was a person discriminated against just by the very fact of losing his job, being in jail for periods of time, but is much more likely to plead guilty, whether he's guilty or not, under pressure, because he's in jail. He can't communicate with his lawyer. He can't prepare a defense. And if he's found guilty, we found also much more likely to receive a prison sentence than the same person who's found guilty and on the outside awaiting trial, because the judges are much more likely to give the benefit to the man who's been able to show he wasn't a menace to the community during this period. He would bring if he had a job, he would bring an employer there or bring his family. Instead, the man in jail before trial would come in often manacled, from ill-shaven, ill-dressed, and appear in court and just look like a jailbird. And that was the fellow, and much more likely would go to prison. So this first early decision, we found, was critical in the whole administration of justice.
New York Police Chief Howard Leary.
We're greatly concerned about having police available. The summons allows us to arrest a person for minor infractions of the law, and when he's brought into the station house, he's questioned as to his stability, his work record, and his social activities and on the basis of those factors, he's released on a summons. This saves many hours of police time. I'm a great believer that the police should prevent as much crime as they possibly can, apprehend the offenders, and produce the necessary evidence that requires a guilty decision. But I don't think we should get into the rehabilitative processes, the detention processes, etc., where you don't have the knowledge, naturally we don't have the experience. And I think it's kind of an invasion of another check within the administration of criminal justice that we shouldn't participate in.
By New York standards, the police in Britain have an impossible job with bail. Firstly, they must supply information at bail hearings. Secondly, if they think it necessary, they can ask for the accused to be remanded in custody. And thirdly, If the accused is granted bail, it's up to the police to pass or reject his sureties, and they have the power to keep him locked up until they're satisfied. One man who was locked up until the police were satisfied is Mick McKenna.
On the first day I went to court, right, on the Monday, the police objected to bail because I live so far away. I live in Oxford, and they weren't sure of my coming back to court to appear. And that's all they had to say.
The objection was hard to understand. McKenna got drunk after the Grand National in Liverpool and fell asleep beside a garden shed. The police charged him with attempting to burgle the shed.
Now, the following Thursday, when I went back to court again, and this, in the meantime, I got in touch with a friend to come up to stand bail for me. I applied for bail again. The police objected on the same grounds. And the magistrates turned it down point blank and referred my case to the Court of Sessions, which wasn't for another 8 or 9 weeks from then.
In fact, it was nearer 6 weeks. He then decided to appeal.
I got a form and all that in the remand centre. Well, I filled in this form and sent it in, and I didn't even know I'd been granted bail until I went to the magistrate, to the Court of Sessions on the Friday. I was granted bail, but one of the two referees, the two sureties I give, whose names I give, one of them wasn't a householder, and that was the police's only reason for not giving me bail. And yet, even at that, they didn't tell me that one of them wasn't a householder, because if they had told me, I could always have got somebody who was. Well, when I was given bail on the Friday, my own surety, all I'd done was sign a form, and I walked out. And I was never as mad as sea freedom by as I was that day. You know, just for the matter of signing the form, which I could have done in the first place, you know.
Hardship and injustice might be avoided if Britain, like America, made bail granting the job of an independent agency. Too many people are inside because nobody took the trouble to find out about them. But it is more than just a matter of a few inquiring phone calls. It is a question of basic justice. A survey in New York before the new system showed that with people accused of the same offences, the ones remanded in custody were 3 times more likely to be convicted than those granted bail. Mick McKenna can consider himself lucky.
The only 2 words I said were, I think, when I was asked not guilty. Apart from that, the boys with the wigs, the barrister, did all the talking, you know. And the jury tripped out. They weren't out for about 10 minutes, and they came back in again and said not guilty. And I didn't know what the procedure was then, but the judge says, you're free to go. And it seemed an awful waste of my time.